Good morning, this is your Kelso Report for Friday, June 22nd. I'm your host, Clark Kelso. Well, the Supreme Court issued a handful of decisions yesterday as it races towards the end of its term. Looks like we'll have the healthcare decision and the Arizona immigration decision next week. But yesterday they decided four interesting cases. First, under the Supreme Court's decision about a decade ago in Apprendi versus New Jersey, the court held that the Sixth Amendment reserves to juries the determination of any fact, other than the fact of a prior conviction, that increases a criminal defendant's maximum potential sentence. That principle has been applied in cases where the sentence was imprisonment or death. A majority of circuit courts had already extended Apprendi to sentencing facts relevant to the imposition of criminal fines. And in yesterday's decision in Southern Union Company versus United States, the Supreme Court agreed that Apprendi does indeed apply to the imposition of criminal fines. So this is another area where underlying facts have to go to the jury, and the trial court can't make those determinations on its own. Next, we have an interesting and important labor law case that actually arose out of the Sacramento, California. The Supreme Court has previously protected the First Amendment rights of members of public sector unions to ensure that their dues are not used for political, ideological, or other purposes not germane to collective bargaining, absent their consent. In its 1986 decision in Teachers versus Hudson, the court identified certain procedural requirements that a union must meet in order to collect fees from non-members without violating their rights, including sending out what became known as a Hudson notice, estimating how much would be spent on such political speech, and securing the consent. In yesterday's decision in Knox versus Service Employees International Union, the court faced a situation where a union had imposed a special additional assessment to raise funds to meet unanticipated expenses associated with combating a statewide initiative. Well, to protect the rights of members who don't want to contribute to the union's political speech, the court held that the union must provide a fresh Hudson notice and may not exact any funds from non-members without their affirmative consent. The decision closes what could have become a fairly large loophole in the Hudson process. Next, we have a case dealing with retroactivity of changes in criminal sentencing. Federal statutes impose mandatory minimum prison sentences upon those convicted of federal drug crimes. These statutes typically base the length of a minimum prison term upon the kind and amount of the drug involved. As I think you all probably know, until 2010, the relevant statute imposed upon an offender who dealt in powder cocaine the same sentence it imposed upon an offender who dealt in 1/100th that amount of crack cocaine. It imposed, for example, the same 5-year minimum term upon, first, an offender convicted of possessing with intent to distribute 500 grams of powder cocaine, as upon, second, an offender convicted of possessing with intent to distribute 5 grams of crack. This was widely criticized for quite a few years as both unfair and, in practice, racially discriminatory. In 2010, Congress finally enacted a new statute reducing the crack to powder cocaine disparity from 100-to-1 to 18-to-1. The new statute took effect on August 3, 2010. The question before the court in Dorsey versus United States was whether the Act's more lenient penalty provisions apply to offenders who committed a crack cocaine crime before August 3, 2010, but were not sentenced until after August 3. This is a question of statutory interpretation, and the court held that the new, more lenient mandatory minimum provisions do in fact apply to pre-act offenders. Next, we have a case from the Federal Communications Commission, the Indecency Police. The FCC found that Fox and ABC violated federal decency laws in the context of fleeting expletives on 2 award shows and momentary nudity on another show. At the time of the shows, this is more than a decade ago, FCC policy pretty clearly indicated that fleeting expletives and brief nudity would not violate FCC's interpretation of the applicable statute. However, FCC policy subsequently changed in another case, and then the FCC applied the new policy to the Fox and ABC shows. In yesterday's decision, FCC versus Fox television stations, the Supreme Court held that the FCC's actions were unconstitutional, because neither Fox nor ABC had been given fair notice that such fleeting broadcasts were forbidden. Accordingly, the court held that the FCC standards as applied to those 3 shows were unconstitutionally vague, and the court reversed the FCC's orders with respect to those shows. This is a narrow holding, since the court does not reach any of the First Amendment issues presented by the FCC's new policy, which still makes fleeting expletives and momentary nudity subject to sanction. The only holding here is that Fox and ABC did not have sufficient notice at the time their 3 shows were broadcast, which, as I noted before, happened more than a decade ago. Now we turn to the Ninth Circuit. First case involving criminal sentencing. In United States versus Wing, as our first case, in Title 18 U.S.C. Section 3583, Congress has established a scheme where separate and distinct terms of supervised release may be imposed upon a repeat offender of supervised release conditions. Each term has its own conditions, as well as its own beginning and end, either by termination or revocation. Well, the defendant in the United States versus Wing had her first term of supervised release revoked, and was about to enter her second term of supervised release when newly discovered violations of conditions of the first term surfaced. The issue for the Ninth Circuit was whether, under the statutory scheme, the district court had jurisdiction to revoke her second, not yet started, supervised release term based on new evidence of violations during the first, already revoked term. Noting that the statutory scheme established separate and distinct terms of supervised release, a majority of the Ninth Circuit panel held that once a term of supervised release has been revoked, a later discovered violation of a condition of that term cannot form the basis of a revocation of a subsequent term of supervised release. Now, the dissent in the case points out that a consequence of the majority's interpretation is to leave a gap between the first and second supervised release terms, where there appears to be no consequence from violating conditions of release. It would not surprise me to see the Supreme Court take this case up, since both the majority and dissent recognize that the applicable statute is ambiguous, and my sense is a majority of the Supreme Court would resolve the ambiguity more in line with the dissent than with the majority. Next, an environmental law case. Back on February 9th, the Ninth Circuit affirmed summary judgment entered against the plaintiff in an environmental challenge to the development at the Arizona Snow Bowl Resort. At the time, the panel opinion expressed frustration that the case had even been filed, since a virtually identical challenge had already been brought by different parties. The result in that prior case favored Snow Bowl, and that result had been affirmed by the United States Supreme Court. The panel described the new filing as, quote, a gross abuse of the judicial process, close quote. Well, the second shoe fell yesterday, when the panel imposed all costs of the second case personally upon the lawyer who brought the case. That lawyer, not coincidentally, was the same lawyer who lost the first case and who simply found some new plaintiffs to bring the second lawsuit, which the court found was in bad faith, had been filed solely for purposes of delay and harassment. A good warning from the Ninth Circuit about how not to be a lawyer. And that's it for today's Kelso Report. Have a great day in the law and a good weekend.